We'll get started in just a minute. We're waiting for the webcast to click in. Oh, okay, it just did. Okay, the webcast is on, so I'm going to go ahead and get started. I want to say good afternoon and thank you all for joining us today. My name is Howard Levinson. I'm Deputy Director here at CalRecycle, and I'll be facilitating this public hearing today, which is on the proposed regulations for the administrative certification for reusable grocery bags. Before we begin, I've got just a couple of housekeeping announcements. First of all, in the case of a fire alarm, which we hope won't happen, but we have an evacuation procedure which we will exit out the back and follow us. We won't be using any elevators. We'll exit down the stairs and we relocate across the street in Cesar Chavez Park. So we'll get you out there safely if there is an alarm, and we take those very seriously for your health and safety. If you aren't familiar with the building, restrooms are located. If you go out the back door, take a left and then another left. There's a couple restrooms there. There's a cafeteria down on the first floor. I don't know how long we'll be here today. We'll see how many comments we have, but if you need to get a coffee or something, please make yourself, feel free to do so. And if you can silence your phones, and if you do have any phone calls, please take them out in the hallway. We'd really appreciate that. This hearing is being recorded. I want to thank the court recorder. So we'll ask you to speak up and say your name. We'll also have a microphone so that people on the webcast can hear your comments. So with that, we'll get started. Today concludes the initial 45-day comment period for the formal rulemaking process for the SB 270 regulations. We're here today primarily in a listening mode and to receive your input as part of the formal rulemaking process. So I want to acknowledge and thank all of you who've already shared feedback with us during the course of the informal rulemaking, as well as providing comments during the 45-day comment period. Since we held the last March public meeting on this, we've received a lot of helpful suggestions, and we do anticipate that there will be some areas in the regulations that can be further addressed and that fall within our authority to address those issues. So we anticipate having a 15-day comment period after we collate all the comments and decide what potential changes to make. So we'll keep you informed of that. We also understand that many of you have concerns about the amount of the initial certification fee, the pending third-party lawsuit, and various definitions. Now, today we are not, as I said, we're in a listening mode, so we're not going to get into a back and forth on those issues, but we definitely want to hear what your comments are on those and other issues, and if you have any suggested edits to the regulatory text, we'd like to either hear those today and certainly get them in writing for us to consider, and then those need to be within the department's statutory authority. So I expect that there may be some of you who may want to make comments on the statute itself, on the pending lawsuit, and other issues that may be outside of the actual scope of the regulations. I will tolerate those kinds of statements, and you're welcome to make them, but I also will ask you to keep them short because they're not germane to the subject of today's hearing, which is the regulatory text itself. So please be apprised of that. We will be accepting comments from webcast attendees as well, and request that, so for those of you who are in the audience who wish to speak, we also would request that you submit comments in writing so that we have a formal record of those, even though we have the court recorder, and we can go back and look at your verbal comments. And as a reminder, we do post comments for the public to review on CalRecycle's website. So all comments should be submitted to the following email address: sb270@calrecycle.ca.gov. It's pretty simple, sb270@calrecycle.ca.gov. Okay, now I'd like to just introduce the team who's been working on implementing the law's requirements and developing the draft regulations. I'll just go to my left first we'll introduce Kate Nitta, who is our attorney working on this, and she's also accompanied by Senior Counsel Elliot Block, who's out in the audience, who's also been working on this. Sarah Keck, at my far left, is Chief of our Fiscal Services branch here at CalRecycle. Brenda Smith, out in the audience, is our Chief of the whole branch that this plastic bag program is housed under. Clark Williams is a manager in that program. Raise your hand, Clark. Wendy Harmon to the front is the supervisor who is in charge of this entire program. And then I think many of you have spoken probably on an almost daily basis with Deke Marshall, Robert Contreras, and Paulina Kolek. So I want to thank all those folks for all the work that they've done. I think they've been really responsive. Even if you haven't always agreed with the responses that you've gotten, I think they've been responsive to listening to you and getting your comments and trying to assuage concerns that you may have about the bill and the regulations. So with that, I will turn it over to Paulina, who's going to make provide a brief overview of the process and walk us through the proposed text. And then we'll open it up to comments, and I'll just try to keep a queue and moderate make sure everybody has a chance to provide opinions or provide comments on the text.
All right, thank you everyone for coming out to the Cal EPA building today. I've spoken with many of you throughout the informal and formal rulemaking process, and I'm looking forward to hearing your feedback, your comments, and also any solutions that you can offer to us today. First, I'm going to go ahead and give a little background about what we've done so far. So in October 2017, we held our first public workshop where we released the draft regulatory text, and we also proposed 2 different certification fee concepts by which the administrative certification fee could be calculated. We accepted comments through the middle of November, and then we looked at that feedback and we made changes to the regulations, and we also selected the fee concept with the most positive stakeholder feedback. In early March 2018, we released that updated draft regulation. And then we subsequently received approval by the director at the March public meeting. An economic analysis has also been prepared by staff, and it's been submitted to the Department of Finance for review. Finally, on June 15, 2018, the Office of Administrative Law published our notice of proposed rulemaking. This began the 45-day comment period. The comment period will conclude today at 5 p.m., and we would greatly appreciate receiving your comments by that time. So a little bit about the next steps. We'll be working on responses to the public comments and also revising the regulatory text after conclusion of today's meeting. We will then have an additional 15 or 45-day comment, followed by additional revisions to the regulatory text. Finally, the regulatory text must be approved by our director at a CalRecycle monthly public meeting before we file the packet with OAL for approval. We anticipate filing this packet with OAL in early 2019, and for the first fee to be charged in July 2019. Now let's go ahead and shift to the regulatory language. The current regulations consist of 6 sections, and we will be going through the regulations section by section. When we reach the section that you wish to comment on, please raise your hand and Deke will bring you a microphone. As Howard said, please clearly state your name, affiliation, and comments for our court reporter. We will also be posting a transcript of the proceedings along with a video of the webcast and also all of the comments that have been received to our website. So let's go ahead and begin with the first section, 17-988.1. Does anybody have any comments on this first section?
Microphone up in front.
Thank you. Stephen Joseph, Coalition to Enforce SB 270. I'm not sure if this is the right section, but I have a question, and I understand this is not interactive, so maybe you can't answer it. But is it the view of CalRecycle that SB 270 is in effect now, or are we waiting for the regulations for it to take effect?
Yeah, the statute SB 270 is in effect now.
So CalRecycle takes the position that it's enforceable now, is that correct?
Yes.
Thank you.
Thank you. Any other, Melissa?
Hey there, Melissa Romero with Californians Against Waste. Just a comment on a couple of the definitions in this section. So the definition of aesthetic change is defined to include any change that a bag has that doesn't affect the results of a chemical test, but some of the color and print variations might actually make that a new, or create a new aesthetic change, even though the bag wouldn't necessarily need to have further physical testing because it's assuming the same bag type. And that should be considered in that definition, as well as the definition of type of reusable bag. Similarly, it includes any difference in results of a chemical test, which might be construed to mean any print or color variation, which doesn't affect or shouldn't affect the reusability or durability of a bag. So just to take those into account. So, for example, if a bag maker has 40 different colors of one type of bag, they shouldn't have to do physical testing for each one. So I believe that's it for this section.
Thanks, Melissa. And again, I presume that you will provide some comments in writing, or I'm asking if you will. Go ahead, Mr. Joseph.
I don't want to miss the right section.
Excuse me, just repeat your name again for the webcast folks.
Stephen Joseph, Council Coalition to Enforce SB 270. I don't want to miss the right section. Is this the section, definitions, where we should be talking about the
Yeah, sorry,
17?
we skipped ahead a little bit. We'll just open to any more questions that are in the scope and purpose.
Okay, so not definitions. Okay.
Okay, any more on the scope and purpose? Okay, let's go ahead and go to the definition section.
Okay, we had one comment on definitions. Would you like to make another comment, Mr. Joseph? Go ahead and give you the mic again.
I have a question to make sure I'm in the right section.
It's okay.
Yeah, we're in the definition section right now.
So is that the section where we would discuss the 17025, 17065 controversy?
Yes, 17025 is defined in this section.
Okay. I have submitted 2 sets of comments on this already. Obviously, it's become a controversial issue. I'd just like to say that I would hope that CalRecycle takes a very pro-recycling view in the way that it addresses this issue. It is very important to the credibility of the industry, to the credibility of the bill, and to the credibility of the entire process, that nothing be done that would make it easy to cheat. My concern, and one of the driving factors, my motivation for the lawsuit that we filed, is to make sure that entities overseas can't file phony certifications, or it may be certifications by real entities, but they may effectively just be checkboxes. And bags are coming into the country that are not really, don't really contain recycled content. And that's not fair to companies here that are complying. It's not fair to the environment, because there's no recycling going on with respect to those bags. And it doesn't make any sense to structure the regulations in a way that would facilitate that kind of cheating. Cheating in the United States, cheating overseas as well. It's very important that we have a robust regime to make sure that companies are audited and checked to make sure that they really are putting that recycled content into their bags. So for that reason, I believe that the legislative intent, which is in accord with that approach and that concern, the legislative intent is that there be auditing of recycled content in order to certificate. That means that the certification must be done by an auditor, and that would mean an ISO IEC 17065 auditor. A lab cannot audit, period. They're not qualified to audit. They're only qualified to do mechanical testing. You can't mechanically test for recycled content. So you have my comments, you have my arguments, you have all the case law that I've cited and everything else. But the most important thing that I appeal to you today is to think in terms of the mission of the agency, to promote recycling and not undermine accidentally the mission of the bill, which is to make sure that recycled content is in the bags.
Thank you, Mr. Joseph. We do have your comments. We will take them into consideration.
Okay.
Thank you. In the back, Deke.
Hi, good afternoon. My name is Lisa Garcia. I'm from Earthwise Bag Company. We are concerned as well about aesthetic change, the definition, as well as the type of reusable bag, because testing proves that the chemicals can change in terms of the difference between two prints or two colors of the same bag type, but the physical testing does not change. So in aesthetic change, we believe if it's only changes the material composition and not necessarily the print of the same bag type, then that shouldn't be part of aesthetic change. As well, type of reusable bag, should be if you have the same construction, same material, same size, different print, that shouldn't define a difference in the type of reusable bag, because that will have a huge impact on the cost of our testing. Huge impact. Thank you.
You. Deke, let's go back to someone who hasn't commented yet, please.
Hi, I'm Chair Shingala with Command Packaging, and we also agree with aesthetic change comments that have been made here, that we believe if it's the same size, same composition, and you're only changing the print, that you should not have to do an additional test given the cost that we incur in doing that. And we can provide all the ink documentation and anything you need to support that it does not change when you change the print.
For the webcast, that was an aside on spelling of a name.
Stephen Joseph, Coalition to Enforce SB 270. Earthwise submitted comments about something that I allegedly had done. I don't know actually what they're talking about.
Excuse me, Mr. Joseph, I think that would not be germane for today's hearing. You're welcome to provide us some comments if you disagree with them, but if we're trying to focus on the regulatory text today.
Well, I am too. This has to do with aesthetic change.
Okay.
Okay, I just wanted to make sure they understood that, and that everybody understood. They said that we had said that a mere change in decoration would be an aesthetic change that would require certification. We haven't, I don't really know what they're talking about. Earthwise, we've removed any objection to Earthwise's certification, and they're being dismissed from the lawsuit. So there seems to be some miscommunication, but I don't know what they're talking about.
Okay, thank you for that clarification. Appreciate that. Other comments on the definitions? Yeah, we got over here. So far, we don't have anything on email from the webcast.
Hi, I'm Nicole Munoz from SCS Global Services. I came today really just to get some clarification on what is the intent of including ISO 17025 and equating it with a certification body entity. SCS does have an accreditation for a certification body under ISO 17065. So for us, this created a bit of confusion when clients and potential clients would come to us and ask us to provide services according to the regulation, and then trying to decide what were the differences between ISO 17065 and 25. So that was one of my greatest goals for coming here, is to provide further clarification in my submission and understanding the differences between the two, and providing the intent for the scope for the two of those. In addition, I just wanted to also get some clarification on item D in the regulation. It states, information demonstrating that the post-consumer recycled material is cleaned using appropriate washing equipment. This has come up a few times for us as well, just in understanding what is meant by appropriate washing equipment. We get a lot of questions on interpreting this information as well. And this section 42285.5D.
Didn't hear the last comment. Was there?
I didn't. Could you repeat your last part on item D?
Yes, my intent is to provide some more clarification, asking CalRecycle what is considered appropriate washing equipment. It's a subjective item there, and we get a lot of questions of what the intent is and what is defined as appropriate washing equipment.
Okay, thank you. And we will take that into consideration on section D. With respect to the two standards and trying to clarify that, that was not really a comment on the regulatory text as it is. I think it would be okay for us to have a conversation outside this regulatory public hearing where we could at least say, here's what the two different standards do, and then you can judge accordingly. Yes, sir.
Hi, my name is Andy Keller. I'm with Chico Bag Company. And there's a couple things that I'd like to address. And it's hard to fit it all in the definitions, but definitions is where it could be fixed. So the first thing is impact on small business. So Chico Bag's a small business, started out of a spare bedroom. And there's a lot of other reusable bag companies that start that way. The regulatory fees, have an impact on the business, of course, but it's the testing that has the biggest impact. That's the biggest cost. To do a full body of tests on a bag is about $2,000. So the definitions are important because if you have to test every single color variation, to the full body of testing, for my bag line, it could cost a minimum of $100,000. And that's with me deciding to reduce my product line. In some bags, we just don't sell enough to justify the cost. So it's going to result in less selection for consumers, less bags on the marketplace. I saw in the regulatory text that or in one of the documents that talks about impact on small business, and it only talks about the fees, but it doesn't talk about the testing costs. And that's a big chunk of money. And so I'd like to just propose that that's also considered when you guys are clarifying this. So in regard to definitions, to support this notion, we want to be compliant, but we don't want to be buried under testing. And I believe it's written that if there isn't a chemical or physical change in the bag, you don't have to register it with the state. I saw that somewhere, and I'm not remembering fully. However, if that's the case, you actually have to test the bag to know. And the testing is the biggest cost. So my comments are related into this. So when testing isn't needed, we don't want to test just the test because there's a big fee associated with that. And if we're going to test, we might as well just register it with the state. So type of reusable bag. I submitted comments saying that a reusable bag is to be defined as material composition, size, and construction, those three attributes combined. And it doesn't include color changes or ink changes. And so that's the composition, size, and construction is what's tested to the dynamic lift test, for durability, that it can be used 125 times. And then any colors and ink customizations, I'd call that decoration, is done using chemical testing. And so every variation of ink and dye would then be subjected to chemical testing. And then aesthetic change would be defined as that combination of ink and dye. If you've already certified that with the state, that you wouldn't have to recertify it if for example, logo changed or the artwork changed, as long as you're using the same formulation of ink and dye on the bag. But if you change from white ink to red ink on a blue bag, for example, you'd have to resubmit that with chemical testing, which is ranges anywhere from $100 to $300 to do that. So it's significantly less of a cost. And then as far as proof of certification, there's some vagueness in that definition. I would say that it involves the dynamic lift testing, the label verification testing, all these different components of the law could be submitted as a separate document, which would be the proof of certification. It wouldn't all have to be in one document, for example. And you wouldn't have to test all the bags in a certain product line, for each of these attributes. You just have to do it once for the bag type, which would be the material composition, the size, and construction combination. That was a lot of information. Is there any questions on that part so far?
No, I think the staff has got that. Certainly, they've heard some of those comments before, so I appreciate you reiterating those and having them in writing as well.
And then the other part that I think could be fixed in the definition section is this issue in the legislation that says 80 grams per square meter is the minimum thickness or weight of material. And I make a variety of bags that are made of woven polyester, which look like this. And this is another variation that's made of basically what's called 190T polyester. It's like a taffeta. When you test this, it's 3 times stronger than 80 GSM non-woven polypropylene. And non-woven polypropylene is the majority of the bags being sold at the checkout before this regulation took place. And now plastic film is the majority, followed by non-woven polypropylene. And the bags I sell are just a tiny minority of the bags being sold. So depending on how you interpret the law, my bags do not measure 80 GSM, but they are 3 times stronger than non-woven polypropylene. So I don't think the intention of the law, when you read it, is to make the bags I make illegal. So the way to fix that could be in the definitions. So I proposed in my written letter that the 80 grams per square meter is a benchmark measurement of durability for non-woven polypropylene, and that a reusable bag maker can certify a test that shows that the material is stronger than 80 GSM non-woven polypropylene, which is the benchmark, to show compliance. So that's one solution. Californians Against Waste submitted a different idea, that this regulation is just for non-woven materials and does not apply to woven materials, which is a simpler way to do it and reduces the testing burden on small businesses like mine. Thank you.
Thank you very much. Other comments on definitions? And we can come back if somebody has comments on a section that you want to bring up later, we can come back to those. So why don't we go on to the next?
Okay, let's go on to the next section, 17988.3, submittal and resubmittal of a proof of certification.
Melissa Romero with Californians Against Waste again. I want to just back up and say that I want to thank CalRecycle staff for all their hard work on this. I think this has become a lot more work than we all anticipated, and you guys are doing an awesome job, so just wanted to give you guys a shout out first. First of all, for this section, I wanted to say that we really appreciate the completeness review that was added. I think that's a great idea. One thing that I think could be added to this section in the subsection about what documentation should be included in the proof of certification is the information required in the statute, section 42281.5, which is the post-consumer recycled content information requirements. So that section of the law, it contains really 3 distinct provisions. So it requires the bags to be certified by a third-party certification entity, requires bags to provide proof of certification to the department, demonstrating the bags are compliant, and then it actually specifies that the proof of certification must include an A through D listed out pieces of information about the post-consumer recycled content. So the A through D provisions require the direct documentation and reporting of the amount, the sources of the PCR in order to comply with the minimum recycled content requirements. And what we've seen some do is just a checkbox of this information was provided, potentially to the certification entity, but the information wasn't actually provided to CalRecycle. It's just kind of a checked off box. And we don't think that's sufficient. And I think that there could really be some explicit language in this section about that information being required to be part of the proof of certification documents. And we think that the implementation of SB 270 would benefit from that. So the regulations, we believe, should clarify that the producers shall provide A through D in the information in that section of the law, that documentation, and that the bag producers must provide the total number or the volume of bags produced during the same time as the reported sources and amounts purchased in order to verify that it does make up 20% of the total. And I believe that's it. Thanks.
Hi, Roxanne Speakerman with Roplast. Just following up on what Melissa had to say, I think we are also in agreement that those items that are necessary to collect the data and information for post-consumer, including the source and volume and everything else, should be accessible. And I would hope that that comes through the certified third-party agency that someone like ourselves would contract to gather that information. So from our perspective, it's readily available. They're asking us for it, so they certainly have it. The other question I have beyond the input is on the initial statement that came out in June 2018, there was a mention in there that the information that's submitted, as long as we tagged it as being proprietary information, that it would be somewhat protected from public view. That was sort of what we got out of the statement that was released in June. Is that correct? Because I know there's also the Freedom of Information Act, and people can still, get this information if they needed to. But this information has a lot of discrete company proprietary information that we really wouldn't want a lot of people to view beyond our third-party agency. So what would be protected?
Hi, Roxanne. Yeah, you are correct that, I'm not sure what statement you're referring to, but that is correct that if companies mark the information as proprietary or trade secret or something like that, generally we will treat it as such. If in the event we want to release information and make it public, or we get a request for it, like through a Public Records Act request, which is like the Freedom of Information Act requests, we would do a review to make sure that the information that has been requested to remain confidential does indeed meet the definitions of trade secret or proprietary and so on like that. And there's a process which we can go through, which I think we actually put it into the regulations just so that the citations are up front for everybody. And it's the last section, 17988.6, that has all the code and regulatory citations that has the process laid out in it. But in general, yes, you are correct. There is a little bit of a review process to make sure that companies aren't just marking entire documents proprietary, and maybe they aren't, but in general, that's where we start.
So there could be a situation, for example, that we put our certification from our third-party agency, we upload it and submit it on the site, but that backup information we could send to you, and we would send it directly to CalRecycle and then flag it as being proprietary information so you have access to that data, but publicly it would just be the checklist of the certification. Would that be the preference?
I'm not sure about the mechanics on how the website would handle it, but we can, I don't know if you know that, but
Yeah, that's something that we haven't actually encountered yet. We've usually been going through each proof of certification when a PRA comes in and looking and redacting that information. And so that would be updates to and upgrades to our system right now that we would have to talk about.
Okay. All right. Thank you.
Oh, Roxanne, could I have you clarify one thing? I believe you said you were in agreement with the CAW's previous statement. Is that also for like providing the volume of bags sold? Or was that
Yes,
for the A through D
we
requirement?
are in agreement with following the original intention of the bill, which clearly states that those particular, key bullet points, volume, source, everything else needs to be provided. Now, I'm also in the agreement that we pay a third-party agency to do that for us, so they should be doing that for us and gathering all that data, and that data should come to you, although it's propriety, and then the certification itself should be public. That's what we're advocating.
Okay, thank you.
Stephen Joseph, Coalition to Enforce SB 270. I agree with what Melissa said on behalf of Californians Against Waste, and also Roxanne, that it should be made very clear in the regs that those 4 sets of documents in 42281 1.5 A through D must be submitted. But 2 issues. First of all, for the first time yesterday, I spoke to a lawyer who took the position, for a producer, who took the position that his client, according to his reading of SB 270, had the option to submit either a certification from a third-party entity or the 4 sets of documents in 42281 1.5 D. And I told him that that was completely wrong, in my opinion. But I wanted to give you a heads up so that you can make sure that the way you address this in the final regs does not allow for that clearly incorrect interpretation. Obviously, somebody is looking just to submit those 4 sets of documents, and those 4 sets of documents really, as listed, are nothing more than the sources of cleaned post-consumer content and the quantities purchased. So in other words, what he's saying is you could just submit documentation showing that a big company that sells a lot of bags in California has bought 100 pounds of post-consumer clean material and never has to submit the certification. So I wanted to give you a heads up that that may be coming down the road, and hopefully you can cut it off at the pass, to use an old cowboy term. The other issue is confidentiality. There are 4 sets of information in the documents that are required by 42281 1.5. One of them is not pricing. So a company I can see would be within its rights to redact pricing information or require that it be kept confidential because nobody else needs to know how much they're paying for recycled material. But the issue of sources of material, whether it's washed and how it's washed, the quantities purchased and so on, that needs to be made available to potential objectors. Otherwise, there is no way for an objector to know what the basis is for the certification. And there's no way that the objector can object. What I've said in my comments is that it is clearly within the legislative intent that the information provided that is necessary in order to obtain listing on the CalRecycle website must be made available to the public, or at least to potential objectors who say they're thinking of objecting or maybe intending to object, so that they can determine for themselves whether or not it's properly submitted, whether or not it's complete and reliable information. And if it's not, then they should be able to go to court. But if it's kept confidential simply because it's marked confidential and it's within the categories of information on the list that have to be submitted to CalRecycle, then I think that's wrong. I don't think that should be confidential. I don't think there's anything particularly trade secret in that information. Pricing, yes, I get it. That's not in the information required. But the information that is required should not be confidential. Otherwise, it undermines the ability of anybody to object.
Thank you.
Chair Shingala, Command Packaging. We also agree with Californians Against Waste and Roplast in this area. The one thing that we appreciate Californians Against Waste suggesting is to put the amount of bags sold. That is not in the law right now. It talks about the post-consumer purchases, so you don't have a reference to how much that means as far as a percentage. So we'd like you to consider that as part of that and provide that along with the certification when that's submitted.
Are there any other comments on the submittal and resubmittal of a proof of certification?
I'd like to see some clarity in regard to, my name is Andy Keller. I'm with Chico Bag Company. I'd like to see some clarity on what it means to resubmit documentation. So, for example, I have a product line that I've been selling for 13 years. It's the same product line, it hasn't changed. And to recertify every 2 years is going to cost a significant amount of money if I had to retest everything. So in the event that nothing's changed, that we haven't changed any of our sources, the material's the same, the construction's the same, the size is the same, can we resubmit our previous documentation as proof of certification? And I would suggest that the answer would be yes, given that's nothing's changed. Otherwise, it's a burden on small business.
Thank you. Doing okay? Okay, we can move on to the next section, and I know we have one comment. Certainly, certainly.
I guess, are we now on the section dealing with completeness verifications?
Yes, with the completeness review.
Yes, we're on that section now.
Yes.
Okay, I'd like to address that. Stephen Joseph, again, Coalition to Enforce SB 270. It's more in the way of a question, but I'm not sure if you can answer it because this isn't supposed to be interactive. I couldn't tell from the way that the regulation was worded what kind of evaluation CalRecycle will do of the content of the documents that are submitted. Completeness is a word capable of different meanings. And I think it's important that CalRecycle at least look at the documents, read them to make sure that they make sense and that they do constitute verification that there is compliance, and not just as a checklist, oh, we received a certificate, we received a document called sources, we received a document called, this. There has to be somebody actually eyeing this stuff to make sure that it's for real and that it does show on its face compliance. I'm not talking about CalRecycle investigating beyond what's in the documentation. I understand that's not going to happen, but at least looking at what the documentation is rather than just a checklist. Could you respond to that? It's very important.
Thank you for the comment. And to be frank, we struggled with that ourselves, sort of, since, as you know, CalRecycle doesn't have direct enforcement authority over the bill. How we can make sure that producers are not submitting just a piece of paper that says, their grocery list on it and calling it a certification checklist. So we've definitely struggled with walking that line. And I believe our intent for this section was to not do a review to the point where we're digging into the lab results and making sure it's compliant with the law and all those technical requirements in the law, but just to make sure that the certifications are complete and they have they're covering every single requirement that type of bag needs to have covered. We agree that this language maybe could be better, and if you have suggestions for how we could word that to make it as clear as possible and as accurate as possible, we're very open to those suggestions because we have struggled with how to make that clear in the regulations.
Well, I did propose language.
Oh, you did? Okay. I haven't seen your comments yet.
Yeah, I did propose language in my comments. Let me just ask you a particular example, which I think relates to what Roxanne was talking about, and also, sorry, I forgot the first name, Melissa. Because I agree that there should be sales information given so that the the amount of post-consumer material has some meaning. If they bought 1,000 pounds of post-consumer material, but they're selling 100,000 pounds of bags in California, well, there's something wrong there. But in that situation where you can see on the face of it that they bought 1,000 pounds, just for example, 1,000 pounds of post-consumer material, but they're selling 100,000 pounds of bags in California, is that something then that CalRecycle intends to reject, or at least review and reject, and say to the company, well, this doesn't comply?
I think the problem with your examples, I agree, yes, in like a hypothetical world, but I think the problem with that example is that particular situation, we wouldn't have the information to make that determination. But my answer is yes, in that if we got something that was on its face ridiculous, we would find a certification incomplete.
Well, yeah, but you can see it just doesn't add up to 20%.
Right. We just don't get that kind of sales data on the bag sales data, so we wouldn't be, that particular example, we wouldn't be able to draw that conclusion since we wouldn't have those data points. But if other data points where we did have all of it and it was on its face ridiculous, then we would. Am I right? We don't have those data points. Okay, just making sure. But yeah, but if it was something that was on its face ridiculous, we would find that incomplete.
I'm not sure. I think that Melissa and Roxanne were...
Oh, you're saying hypothetically if we did have that data?
Yes.
Potentially, then yes. It's hard for me to say since we haven't seen anything like that before, and we're not getting that kind of data now. But I guess hypothetically we could. That's
the critical metric.
Right. Well, unfortunately, with the way the law is written, we only get what we get.
Right. Is there an idea that you're going to ask for sales information to be submitted?
I think that's what some of the comments are proposing, and we're going to take all the comments into consideration.
Well, I would support what Melissa and Roxanne said about that. Certainly that should be submitted.
Hi, Mark Murray with Californians Against Waste. I'll stand. I'm going to echo Melissa's thanks to you guys for your thoughtfulness in doing this. Just want to add just a little bit more detail to our comments on this section. So again, echoing that the data has to be provided. It can't just be checking the boxes. There is no minimum recycled content law that CalRecycle is implementing right now that doesn't require the producers to share both the sales information, the total sales information, and the PCR information. So I think it's understood that information needs to be provided. There's just no other way to do the calculation. There's no test. So you have to have that information. I don't believe that is proprietary information, the totals on that. Under AB 2530, you are already making that information public. The total volume of PCR that the beverage industry is using and the total sales. So I'm not sure that there's nothing in this law that says this information would be proprietary. Generally, CalRecycle has, in the Public Resources Code, considers recycling information to be proprietary. But there's a specific example in a minimum content law where the legislature said, we're making this information public. There's nothing prohibiting that in this statute, so I would think that the total information, the total volume of bags sold, and the total amount of PCR used by each bag manufacturer would be public information. And you can't make a determination of post-consumer recycled content percentage without that information. Finally, I think the law, again, adopted in 2014, assuming implementation at some point in the future. Now we're talking about regulations for something that's already in place. But I think that this section, the rules in this section need to provide some kind of timing context. What is the time period for which a manufacturer has to provide the A through D requirements, the total volume information? So it seems that maybe there's going to be implementation guidelines or something, but it seems that there should be something on that timeline. We think that the manufacturers are going to need to demonstrate that for a 2-year period, for the same 2-year certification period. Now, whether that's a year back and a year forward, or, I think we're, open to what's practical in terms of I'm submitting a certification for bags that I want to sell in the future, and I'm providing you with information about something that I did in the past, and or I'm going to continue either directly or through a certain third-party entity to provide this raw data on an ongoing basis. So I think that could be clarified here as well. Thanks.
Thanks, Mark.
Roxanne Speakerman, Roplast. Just following up on that, I also agree that the sales information needs to be on there. This really sounds like a good case for an auditing certification program, and that's where 17065 really kind of comes back into the scenario. If CalRecycle wants to be in a situation where you can trust the data that's being submitted, I would think that you would want it to be more of a certified auditing system that is established to do this through a chain of custody that they have been using for several years. This is already a auditing protocol that is well established. So as Mark was talking about timeline, which is very important, it can't be post-consumer that we bought 5 years ago, and now we're submitting information today. There needs to be a timeline. It needs to correlate with what was purchased, what was produced, and a 17065 auditing program goes through all of that. It's a well-established system. So I'm just saying that might be more support for considering that.
Nicole Munoz, SCS Global Services. I just wanted to agree with both Roxanne and Mark's statements. I think as part of a verification program, the practicality of implementing something is being very specific of what you're looking for, the data points. I mean, those are things that we have in our program manuals to say for recycled content, the data period collection is a year or 2 years or whatever the requirements might be. But those are established protocols that just help the process, make things clarified, and what you're looking for and what the end result or certification is that you're trying to gather, such as the regulation and recycled content for SB 270.
Anything else on that section? Mr. Joseph?
Everything I've heard, Stephen Joseph Coalition to Enforce SB 270, everything I've heard from Roxanne and from Mark Murray and Melissa, I agree with. We seem to be on the same page. So you're listening to the environmental community and the industry saying the same thing, that there needs to be real verification of post-consumer content. 17065 is the only way to do that. An auditing protocol exists. SCS has an auditing protocol. I think it's 17065:2012, I think is what it's called. So there is a way, there is a whole huge document about how you conduct audits and what the methodology is. For a lab, there is nothing. There is no auditing protocol at all. They don't know whether to look forward or backward or anything else because there's no protocol applicable to labs. A lab cannot audit. A lab can only test physically. And by the way, in that regard, A2LR submitted comments saying they support. I'm not quite sure what they were saying. They talked about 17025, but they said that a 17025 lab can do, quote, can test for, quote, chemical and physical requirements. Well, post-consumer content is not a chemical or physical requirement. So A2LA's letter seems very supportive of our position as well, that it has to be a 17065. Only an auditing entity can audit. And this whole issue about whether you go forward or back, that's also very crucial that Mark Murray has raised. The lab certifications that we've seen don't indicate whether they're looking forward or backward. It just seems to be like a one-off. You pass, 4-5 check boxes marked, end of story. An auditor has a process that's continuing. There's continuing reporting. Their certificates are only issued for a limited time. I think SCSs are issued for 1 year. And you have to keep reapplying to make sure that you're still in compliance. That's the level of auditing that is necessary. That's the level of auditing that gives credibility to the process. And it's the level of auditing that CalRecycle can trust. So when it's evaluating documentation, it knows that a proper audit has been done rather than a lab signing off 5 check boxes.
Mark's got a comment.
Mark Murray with Californians Against Waste again. So on this question of the certified entities and the types, the ISO types, I mean, I wish the legislation had spoke to this specific issue of the second type of certified entity, so to speak. I think the only thing that is problematic that potentially creates an issue here in terms of some of the issues that Stephen and others are raising is the decision in the regulations right now to include in the third-party certification entity to include the reference to section 42281.5, which has the A through D requirements. And so I'm not sure that that addition is adding any value to the lab stuff needs to be done by a lab. The statute tells you it's got to be this 10025 lab certified entity. But I think your regulations can list the criteria for the kind of work that a 10065 entity does. I don't think you necessarily, if you don't feel that the statute provides you the authority to specifically reference that kind of entity, nothing precludes you from including the exact kind of, here's what we expect the generic certified entity, here's the kind of thing that we expect them to do without specifically referencing the ISO 1065, if you don't feel like the statute is giving you the authority to do that. So it's a way of accomplishing the objective. I think that the points have been raised about the appropriateness of the 1065 certified entity are right on target. And I'm sorry that the legislation didn't speak to that as clearly as it might have. But there's nothing that precludes you from requiring the same criteria that ISO specifies for a 1065 entity.
Stephen Joseph, Coalition to Enforce SB 270. I agree with Mark Murray. What we have proposed in the language is that the language state that the entity only certify within the scope of its accreditation. So it has to be an ISO IEC entity that does the certification, but you cannot, but it has to say but what we propose saying is that because a 17025 accredited entity cannot audit, then a 17065 ISO IEC 17065 entity is the only acceptable certification entity for CalRecycle. You have the discretion because you have to do the evaluation. You have discretion in this area. And there's no reason why anybody should force CalRecycle to do an evaluation that is outside the scope of an ISO accreditation. It's clear that the law requires that companies operate within the scope of ISO accreditation. And therefore, it's fine for you to say in the law, entities will only be accepted as certifying entities if they're operating within the scope of their accreditation.
Okay, thanks for all those comments. We will, as you might expect me to say, we'll take them under consideration. We'll take more comments on this, but it sounds like we're starting to get into a little bit of negotiating amongst the stakeholders, and I think all the comments are great, so I appreciate them, but I think unless anybody has something new, we can move on to the next section. And then we can come back again if somebody wants to reiterate something.
Okay, let's go ahead and move on to the next section, which is 17988.4, the administrative certification fee.
Oh, and we have, go ahead, Melissa, and then we'll go to the emails.
Melissa Romero again with Californians Against Waste. So you might have seen the joint letter that was submitted, and the concerns that we have about the fee as proposed is that the proposed methodology for allocating the costs among the participants would fail to recognize that there is a higher cost to reviewing and accepting those A through D information, PCR information pieces that we were just talking about from the plastic film bag producers versus the non-plastic film bag producers. and the higher costs associated with just reviewing and accepting those documentations from the larger bag producers versus the smaller. It may also have the unintended consequence of diminishing the number of businesses that are participating, as the cost is, going to be high. And it may also result in the administrative fee revenue not creating enough revenue to cover the total cost of implementation. And so we're hopeful that CalRecycle will consider a more tiered administration fee schedule. That way, if there is a bag producer that's selling less bags in the state that isn't required to do all the things that plastic film bag producers are, that they should pay a lesser fee than the larger companies. Thank you.
Thank you. And let me go to Robert. And we got at least one email from the webcast, so why don't you go ahead and provide that comment.
So this comment is from Frank Lavarini, who is the general manager of One Bag at a Time. Frank indicates in summary that CalRecycle chose no for question 7 on the Form 399, which reads, will the regulation affect the ability of California businesses to compete with other states by making it more costly to produce goods or services here? Frank recommends that the certification fee should be aligned to a tier system based on the size of the company that eliminates large out-of-state producers' competitive advantage. When fees are equally distributed as proposed, this approach puts smaller California companies like mine, Frank's, at a competitive disadvantage.
Thank you, Frank, for that comment. Was that it? Was that all the emails?
That's all.
Oh, okay.
Andy Keller with Chico Bag Company. I also support the tiered approach to the fee structure. I think splitting this equally between billion-dollar businesses and small business is not equitable for a couple of reasons. Like Melissa mentioned, the two types of bags, the plastic film bags and the other reusable bags, have different certification requirements, and there's a different workload associated with those requirements. So the provisions A through D that we were talking about for recycled content is one example of that. And that's a significant amount of work for the department, which should correlate to the fees paid by these companies. Secondly, the amount of documentation that needs to be provided also needs to be stored on a server, needs to be maintained, needs to be backed up. All that has overhead costs. So as far as attributing overhead costs, into this fee structure, the larger companies that have this larger certification requirement ought to pay a larger fee based on that as well. And then in addition, there's other requirements in the legislation, such as store recycling program, and there's a website for consumers. There's lots of Q&A and lots of resources available. That's all administrative overhead associated with the legislation. And basing the administrative fee based on number of bags sold into the regulated marketplace is a good proxy for associating these costs to the bag makers, because the logic is the more bags you're producing into the marketplace, the more resources that are being used from questions or regulatory issues or store compliance issues or recycling programs and all these things. The more bags you produce, the more bags need to be recycled, and that's a cost associated with this. So I've thought a little bit about how do you do that, right? So if you have a tiered structure, how do you attribute costs? One idea is to first ask all the regulated bag makers who intends to renew in the biennial renewal period, and what tier are you at based on volume of bags. And then you get your responses back, and then you calibrate the tiers based on how many players are at each tier structure. And I have a model I can share with you via email and a spreadsheet that basically has a standard model where there's a direct correlation between costs and number of bags produced and sold into the regulated marketplace. So it's a fair system, it's equitable, And it's easy to administer if you ask the question first, do you intend to renew, and what tier will you renew at? That also solves the other problem of right now with the current fee structure. As soon as you charge a bag company a fee, people are going to drop out of the marketplace. So you already have the issue of not collecting enough fees to cover your operating costs. Because as soon as you charge the fee, people are going to drop out and you're not going to collect as many. So asking that question up front of, do you intend to renew at this fee structure, would solve that problem in either format, whatever choice you wanted to go with, if it's split equally or a tiered program. So I encourage you to do a tiered program because, frankly, paying $20,000, which as an upfront cost, plus the certification fees that I mentioned before, the testing fees are even larger than that. For a small company, it's unbearable. And essentially, it's going to result in companies dropping out of the marketplace, companies never even being created because the wall around this industry is so high that people cannot enter it. The gap between the rich and poor is only increasing, and putting a wall around the industry with a fee like this just antagonizes the issue where small businesses can't even get started because the fees are so high. So I'm not advocating for myself. I'm really advocating for all the small entrepreneurs, that want to start businesses that won't be able to because of this regulation if we don't do the fee structure correctly and in an equitable way. Thank you.
Thank you. And if you are willing to share that model, we'd be happy to look at it. Assume there's no proprietary information in it. So. Okay. Any other comments on this section, or shall we move on? We certainly understand the comments regarding 2 tiers. We appreciate those comments.
Okay, let's go ahead and move on to the next section, 17988.5, procedures for submitting payment to the department. Are there any questions?
Okay, keep on going.
Okay, and then the last section, 17988.6, on confidential and proprietary information. Feedback?
We've obviously already gotten some comments on that, which we definitely understand your concerns. Still nothing on email. Okay, so we've gone through all the sections. What I'd like to do now is just kind of reopen. If anybody would like to make any additional comments, add on to something that you've already, comment that you've already provided, or provide additional clarification, you're free to do so. Got a few hands, so thank you.
Roxanne Speakerman, Roplast. Quick question. I think it was Nicole that had brought it up earlier under definitions, but it was the appropriate washing definition. Just to kind of circle back to that, although we agree 17065 is a good chain of custody auditing process for post-consumer, this subject has come up. And the bill is actually very clear in how it defines what post-consumer is. It uses the EPA's definition for post-consumer, which I think is probably the most important component of that section of the bill. And I know that people or entities such as the APR have weighed into this as well. And it's our belief that the appropriate washing or reprocessing, whatever term we call it, the bill defines it as washing, should be closely associated with the quality of the feedstock, the post-consumer. And that the process or the technologies involved in it should be adequate to wash the post-consumer. Post-consumer is already defined under the bill. So has CalRecycle made any type of determination on how they interpret that, or will there be any future review of that?
Hi, Roxanne. Wendy Harmon. I just wanted to let you know we have been in conversations with the Association of Plastic Recyclers. They haven't issued any sort of formative determination whether wet or dry is appropriate or inappropriate, but we did discuss the feedstock issue. So I can just tell you right now that's something that we're continuing to research, but we certainly haven't made a formal decision as we haven't discussed all the comments that we've received yet, either with our legal team. So I hope that helps.
Okay, thank you, Wendy.
See a few faces pondering whether they want to provide additional comments.
Stephen Joseph. Do I need to keep saying my name?
At least your name. You don't need to state your affiliation.
Stephen Joseph. Trex has put out into the marketplace a certification by, I can't remember the name, but it's a 17025 lab. I think it's QI or IQ or something like that, something with a Q. And basically it says that their recycled material their recycled material conforms to SB 270. Something along those lines. I'd have to find it. I didn't know I was going to have to bring this up. And then, so what you have is a lab certifying that the material has been properly cleaned rather than an auditor. Again, it's not something that really a lab can do because it's an auditing function. So I wanted to give you a heads up that that is out there in the marketplace. This whole issue of how you check on this. Is that a lab, something a lab can do? Because it seems to be something an auditor would have to do. It's a process. It's part of the chain of custody. So I'm just giving you a heads up that that's out there.
Can you clarify really quick? I think you said that QI was a 17065.
You think it's a 17065?
No, I was clarifying. Is that what you said?
No, it's a 17025. It's a lab. If I said 17065, I meant 17025 lab. So Trex is, I think, I'm not quite sure, marketing post-consumer material as if it's as if it's SB 270 compliant because they have a lab certificate, which gives you, by the way, no information about how it's cleaned. Nothing. Just says it's cleaned.
Thank you. Okay, if I'll just stall for a moment. Okay, I do see a hand. We'll keep it open.
It's Andy Keller with Chico Bag, and I was just thinking about the split on the tiered structure as far as fees and how to make it equitable. And I just want to reiterate to really encourage, a tiered structure because there are a number of players in the marketplace that really like it being split evenly because it will effectively push small players out of the marketplace. And, and that's real, so it's really important to counter that kind of idea because a vibrant reusable bag marketplace is really critical for the economy, for business, and and for consumer choice, and ultimately to give people the ability to have a high quality reusable bag. Thank you.
Thanks, Andy.
I found the Trex certificate, which I can send to you.
Stephen, just say your name again, please.
Stephen Joseph. I found the Trex certificate, which I can send to you, Dr. Kolick, but it is from QAI Laboratories, and it says, sorry, I can't see on my phone. Plastic pellets are appropriately cleaned and verification of recycled content. Verified for use as a 100% post-consumer recycled content raw material that is cleaned during manufacturing, used in the production of various plastic products. And that's it. It's just simply a one-page certificate with no information. So that's something that we would find to be problematic. Hopefully you will too.
Thank you. Okay, I'm going to wrap up. If anybody has a last comment, you can still get it in. But I want to thank everybody for your comments. I know many of you have already submitted these comments in writing, so we really appreciate that. If there's any clarifications that you want to provide us on your written comments, that's great. If you haven't provided written comments, we still, although the 45-day comment period is over, CalRecycle always listens to comments. They're certainly the ones that are submitted within the 45-day comment period we have to formally respond to. So our next steps will be to take all this input, the input we've already gotten from the letters. We will be discussing this internally amongst program staff and with our legal counsel, because any things that we want to revise or make a proposed revision to, it's going to have to be something that we believe is within our statutory authority. And certainly some questions have been raised about that throughout the course of these discussions. And we understand those concerns and those comments. So I don't have a time frame for when we will be coming out with a second draft. We likely will do a 15-day comment period, at least one. That may take a month or two or conceivably more to get that done. But stay tuned on the listserv. We will let you know as soon as we have that revision, and when the material is submitted to OAL and OAL approves it, we'll start. No, we don't have to do that. We will just start the 15-day comment period, and we'll give you a date certain when that's going to start and when comments would be due by. Anything else that anyone wants to add?
Hi, this is Wendy Harmon again. I just wanted to thank you all for submitting language to us. Your suggested edits are very helpful and informative to us, and it gives us a starting point, even if what we've received may not meet, the exact criteria we need to consider under our statutory authority. But thank you again.
Sign-in sheet. As you're leaving, if you haven't signed in, there's a sheet on the back table. We'd like to make sure we have everybody's correct address, name, and affiliation so that we can make sure you're in the loop on getting informed about next steps. Again, I want to thank staff, all the folks involved here at CalRecycle, but I really want to thank you all as stakeholders who have a vital interest in this program, and your comments really mean a lot. So thank you very much. And we are done.
Thank you.